Good evening, everyone. On behalf of the Pro Bono Week Committee, I am delighted to welcome you to a special event taking place during Volunteers Week, hosted jointly with LexisNexis and the National Pro Bono Centre. This event is over half a year since the panel last convened during Pro Bono Week in November, and we're now less than 6 months from the next Pro Bono Week, which takes place in the first week of November. It will be a very special Pro Bono Week because it will be the 20th anniversary. And for this milestone week, the first week of November, we're going to look back at developments in Pro Bono over the last 20 years, as well as look at the future of Pro Bono over the next 20 years to come. So all I would say at this stage is to let you know that Pro Bono Week will be happening in November. It was very successful last year with only over 2,000 attendees to events taking place across the country. And we hope all of you will get involved when it comes to November, whether it's attending events or even organising your own. So with that plug, looking ahead to Pro Bono Week, I'm delighted to welcome our chair for this evening, Catherine Baksi. You'll probably all be aware of her career. She was formerly a barrister. She's an award-winning legal journalist. She's written for The Times, The Brief, The Guardian, various other journals. She's appeared on Sky News and many other outlets, and we're delighted to have her chair tonight's panel. So with that, welcome again, and I hope you enjoyed tonight's discussion. Thank you very much.
Thank you very much, Toby. Good evening, and thank you very much to the National Pro Bono Centre and LexisNexis for inviting me to chair this discussion. They've lined up a stellar panel, including 2 baronesses and a president. First, Baroness Hale of Richmond, dubbed by Legal Cheek the Beyonce of the legal world. She was the first female law lord, then in 2009, the first woman to serve on the UK's Supreme Court, becoming its first woman president in 2017 until her retirement last year. She became a household name after giving the 11-strong court's unanimous ruling in the prorogation case. Who can forget her words then? The Prime Minister's advice to Her Majesty was unlawful, void, and of no effect. The prorogation was also void and of no effect. Parliament has not been prorogued. For at least the next few weeks, Baroness Hale is also a member of the non-permanent judges on the final Court of Appeal in Hong Kong. Our second Baroness is Baroness Helena Kennedy QC, human rights barrister at Doughty Street Chambers and Labour peer. Among the many hats that she wears, she is Chair of Justice, the British arm of the International Commission of Jurists, and Director of the International Bar Association's Human Rights Institute, which in 2019 gave Lifetime Achievement Awards to the Hong Kong lawyers Margaret Ng and Martin Lee for their lifelong defence of freedom, democracy, and the rule of law, both of whom have been convicted for taking part in protests in the former colony. And Helena infamously found herself on the list of those sanctioned by the government of China earlier this year, something which we will doubtless come back to later today. Now for our president, Stephanie Boyce, the 177th president of the Law Society of England and Wales, the 6th woman, the first Black office holder and the first person of colour, and the second in-house solicitor ever to hold that post. Stephanie was admitted as a solicitor in 2002 and practiced in the fields of corporate governance and professional regulation. She started her career of mostly in-house jobs, joining the disciplinary arm of the Bar Council as a senior investigations officer. She held other in-house roles with Ofsted, the pension regulator, and the Chartered Institute of Arbitrators before taking a master's degree at King's College London in public law and global governance. Stephanie became a fellow of the Chartered Governance Institute and 4 years ago launched a corporate governance consultancy. Iain, yes, sorry, Iain, I just wanted to check that was right, forgive me. Iain Anderson, originally a business journalist, he is the founder and executive chairman of the Cicero Group, a marketing and communications company, and is an expert in integrated communications, global political risk, and public policy. He has over 25 years experience in communications and has also worked for a range of politicians, including Ken Clarke, on his leadership bids. I am told that Iain is also a tennis geek, an Arsenal season ticket holder, and an opera nut. Lastly, James Harper, who I think chaired this event last time round, he's been promoted this time to panelist. James is the legal director and senior counsel at LexisNexis, with a remit to support on UK and global matters. I'm advised that advancing the rule of law around the world is the central objective of the global LexisNexis group. In line with that and James's personal passion for access to justice, he leads LexisNexis UK's work in this area with a focus on supporting digitization in the free legal advice community. As Toby said, last November, with a very similar lineup, the panel came together at the start of Pro Bono Week to consider the rule of law and access to justice. I was a member of that virtual audience then. Then the panel cited among the biggest threats to the rule of law, criticism by parliamentarians of lawyers and judges, the backlog of cases in the court system, the complexity of the law, particularly regarding the volume and ever-changing nature of the coronavirus laws, the rise of populism, the government's plan to reform, that's to say limit judicial review, the process by which decisions of the state or public bodies can be challenged, and the lack of public appreciation or understanding of the rule of law. 6 months on, where are we? The situation has arguably deteriorated, with lawyers still being attacked by politicians for doing their job, a backlog of over 57,000 cases in the Crown Court and trials being listed in 2023. Every prosecution brought under the controversial powers introduced at the start of the coronavirus pandemic being found to have been wrongly brought. The government's stated aim to go beyond the recommendations of the Fulch Review of Judicial Review to limit judicial review. The post office scandal, the biggest miscarriage of justice in British legal history. The last Hillsborough trial collapsing with no one found accountable for the death of 96 people. Public rows and litigation between gender-critical feminists and trans rights activists over the law in the Equality Act and how competing rights should be balanced. Allegations of bullying among the judiciary, and not to mention the deteriorating situation overseas, particularly in Hong Kong. I could go on, but that's for the panel, and it's them you want to hear from, not me. But before we turn to them, I've been asked to provide the LexisNexis definition of what we mean when we say the rule of law. So don't quibble with me if you don't like it. Their definition is made up of 4 principles. Number 1, everyone is equal under the law. That's to say, the law applies to you the same, no matter who you are. 2, everyone should have access to the law so that they know what it says and can use it. Number 3, the law should be administered by an independent judiciary, not one that is subject to corruption or government oversight. 4, everyone should have access to legal support, advice, and a remedy. So, with all of that in mind, to begin the first part of tonight's discussion, it's called The State of the Union. What has changed in the last 6 months since you all came together, and what are the main threats to the rule of law? Baroness Hale, may we start with you?
Well, thank you. But actually, you've said it all, haven't you?
Oh, should we go?
You've said everything that I was going to say. So I'm not sure what I've got to add to it. Thinking about the last, sorry, I can go home. I am at home. But thinking about it last time, I thought that the emergency powers that the government were using to counter the pandemic were a threat to the rule of law because they introduced new laws without proper parliamentary scrutiny, they included draconian powers of enforcement, and they fudged the distinction between law and guidance. Now, all of that is still with us, at least until the 21st of June. And even if we do come out of the regulation on the 21st of June, the power to do it again is still there. and I have very little doubt that it will be used again, because these things are habit forming. Added to that, of course, as you mentioned, there is the threat which emerges, but may not be realised, from the government's desire to rebalance the constitution in its favour. The Independent Review of Administrative Law report, the Fawkes report, was perfectly sensible and moderate and said that nothing much needed to be done. But of course, the government response to that was, well, we've had this independent report, but actually we do think rather a lot more needs to be done. They're consulting on that, and I very much hope that nothing so serious will emerge from it. And I don't want to make anybody's life any more difficult by expanding on that. But nevertheless, those are the threats as I see them.
Do you think, may I just follow up on that? People have sort of childishly blamed the Supreme Court, and particularly its decision in the prorogation case, for the government's desire to limit judicial review. How do you respond to that?
Well, it may or may not be part of the motivation for the government's desire to limit judicial review. But in fact, all governments want to limit judicial review because it's not much fun being told that you can't do what you want to do because it's not lawful. So the prorogation case was just a very well publicised, famous example of exactly the same thing. But blame seems to me to be the wrong word, if you'll forgive me for saying so, because we had no choice. We had to do what the law said we should do. And we all agreed on what the law said we should do. So I cannot believe it can possibly be a matter of blame for independent judges to decide a case in accordance with their judicial oaths. If it is a matter of blame, well, that really is a threat to the rule of law.
Thank you. Helena, perhaps can we turn to you next? If you could, I don't know, shed some light both on the judicial review, but also on why it's so important that the UK has all its ducks in a row on judicial review when it comes to addressing situations such as that in Hong Kong.
Well, I mean, let me pick up on what Brenda Hale has said. I share her concerns about the way in which there has become a sort of tendency to make changes to law without Parliament playing its proper role. And of course, you can use a pandemic, you know, in order to do this. You know, it gives you a ripe excuse, and the public are lured into thinking, well, what else can a government do, and so on. But I've watched, you know, in my role now running the IBA's Human Rights Institute, I've watched COVID being used as an excuse around the world by governments to do pretty bad things. And they all say it's because, you know, we haven't got time to put matters before Parliament, and then they greatly limit the rights of citizens. Or people living within places that wouldn't really be called a democracy. But in democracies too, we've been seeing this great erosion. But we're just now talking about the United Kingdom, and then I'll have a word about Hong Kong in a minute. But I'm very concerned, and I'm not restrained in the way that someone who's had judicial training and who has been a very senior judge might be more restrained in what they're saying. I do believe that that we are seeing a government that was, I mean, those who are the executive are made up of people who put a political complexion on the decision that was made by our Supreme Court, which, as Baroness Hale has said, was actually our Supreme Court doing what it had to do, which was a proper review of whether what was taking place in proroguing Parliament was lawful or not. And it was unanimously decided that it was not lawful. And we even have Lord Sumption, who's not any kind of bleeding heart liberal, saying that he felt that it was a decision that he would have made too. So this was judges doing what judges should do where they're committed to the rule of law. And of course, there are a cohort of people in government who don't like that. And so I'm afraid it's being used as a motivation. I would use the word blame. They like to blame the judges, and they are seeking, therefore, to use it as a machine to, first of all, look at the complexion of our judiciary and how judges are appointed and so on. And that fills me with great concern because it's still being discussed, certainly in political circles. But I also thought it was really remarkable that there was Lord Foulkes, sat on the Conservative benches, was a government minister, given the role of looking at the business of administrative law and judicial review, comes back with a very restrained report saying, having looked at it all, he didn't feel that there was this problem, which is that and what is being said is that this is embarrassing for judges. You see, they want to reform judicial review in order to protect the judiciary from being drawn into that filthy world of politics. And in fact, we know that it's about law and it's about, it's about legality. And so his report now is being pushed to one side because they don't like, you ask somebody eminent who is a lawyer, who's in fact shares your complexion politically, to do a review. You don't like the outcome, so you say, we'll do it again till we get the answer that we like. And so they were very complaining about that whenever there was a talk about over the Brexit thing of trying to have a second referendum, that you keep going back in order to get to hear what you want to hear. So I am very critical of the way in which this is being done. And I think that there is a political intent in all of this. And I think it is about a cohort of politicians who are disrespectful of law and the rule of law.
And not just the coronavirus regulations, but now we've got the police and crime and sentencing or courts bill seeking to limit protesting.
On my list of things about what has changed in the last 6 months, I mean, there are a number of things that have concerned me. The right to protest, of course, is fundamental in a democracy, and the rule of law is one of those things that, is conjoined with true democracy. And so I'm very concerned about that. But I'm also concerned about the growth of impunity. And we saw that. I didn't like the idea that we actually arrange impunity in advance for informants, whether they're at the James Bond MI5, MI6 end, or informants to the police. I think that it is not something I like. I want to see in our system, and I've regretted that. I thought the Overseas Operations Bill was a shocker, where they were prepared to actually give impunity in relation to torture. And it was only after the outrage that was expressed in the House of Lords that in fact this was revisited, and they added that there would be an exemption made in relation to military personnel who might be involved in torture. But to not include it in the original bill as an exemption was quite extraordinary, and again was disrespectful of international law, which we've signed up to, which is part and parcel of the rule of law. And I'm very concerned about the subtext in wanting to look again at how judges are being appointed and to give much greater powers to the political class in making those sorts of decisions. So I think that we've got a lot to be worried about going forward.
We're doing ladies first here, so the chaps have to wait. Stephanie, what's been on the Law Society's list of things that have got worse over the last six months, and what have they been speaking to government most keenly about? And also, if you could give us some any intel you have on the judicial review future, what's going on there?
Absolutely. So we, the Law Society, of course, take our role as custodians of the rule of law very seriously. And part of that role entails constantly monitoring the status of the rule of law in other jurisdictions as well as in others. But, much of today's conversation will focus on current and anticipated threats to the rule of law, and then understandably so. But the rule of law is the foundation of orderly, healthy and prosperous societies. And as such, we must always be on the lookout for any cracks in the masonry, lest the whole edifice come tumbling down. But in doing so, I think it is important that we don't inadvertently give off the impression that the rule-based order is in some kind of terminal decline. I think far from it. Faith in the rule of law remains very high in this country today. In March this year, as part of Justice Week 2021, the Law Society, the Bar Council and Silex together published a survey which found that 7 in 10 people in the UK believe that the role the law plays in protecting individuals' freedoms to be important or very important. And more recently, the Law Society published data in April showing that 94% of the British public believe it is important that the UK is seen as a country that upholds the law. But notwithstanding what we will say today, it is important to remember that the ideals underpinning the rule of law retain a great deal of support from people in this country. But in line with that duty I mentioned a few moments ago, there are 2 threats to the rule of law today from as the Law Society sees it. And that is, of course, the reform of the Judicial Review and the Human Rights Act, which we've already spoken about. The reform programme the government is taking forward with regard to judicial review, and we've spoken about the government commissioned an independent review to make recommendations, which reported this year, and subsequently the government consulted on further proposed reforms and a commitment to bring forward the Judicial Review Bill. Implementing these was included in the Queen's speech. Now, of course, there is no particular reason why reform of judicial review should pose a threat to the rule of law. However, some of the changes the government is considering implementing could have the result of limiting access to the courts, restricting judicial discretion, and denying effective remedies to those who have been wrongfully or wronged by unlawful acts. And some of the evidence on which the government is basing its proposals is flawed. And it is notable that several of its proposed reforms were considered and rejected by the independent review, which again we've spoken about. So it goes without saying that government should proceed with caution before making potentially far-reaching changes to the legal apparatus. And the Law Society will be scrutinising any measures that may be brought carefully with a view to protecting the rule of law. And at the same time, another government convened independent review body, this time looking into the Human Rights Act, is currently still at work. And so while it would be too early to second guess what proposals might emerge from that review, again, we will have to scrutinise carefully the impact they may have on individuals' ability to enforce their rights. So the second main threat to the rule of law in England and Wales is the parlous state of our criminal justice system. So the Law Society has been warning for some time now that the criminal justice system is in dire straits as a result of chronic underinvestment. And that is not because of the pandemic. The pandemic, if anything else, has perhaps exacerbated matters. But, you know, at least 6 months ago, my predecessor, David Green, said the same thing. So this is because of a failure to increase legal aid rates since the 1990s, exacerbated by an 8.75% cut in 2014, is driving criminal legal aid firms out of business and deterring new entrants to the criminal defence profession. The potential consequences of this is severe. And without a functioning defence profession, people accused of serious crimes could be effectively denied a fair trial and risk being the victims of serious miscarriages of justice. And these repeated warnings have gone unheeded for years. So the government is currently conducting a criminal legal aid review, which may hopefully lead to some progress on this issue, because unless urgent action is taken, I fear the criminal justice defence sector, and with it the whole criminal justice system and the rule of law, could collapse. So we welcome the review chaired by Sir Christopher Bellamy. The Law Society is calling on interim fee payments for our colleagues. We're told that the review will publish its report by the end of the year, but without a definite date known, there is concern as to how many other firms will go out of business. we've seen between 38 to 40% of criminal legal aid firms disappear over the last 10 years from 2010. That is a significant amount of colleagues who and criminal defence solicitors who've gone out of business.
Thank you, Stephanie. Iain, do you share Stephanie's perhaps more positive than the other take on the situation, or you know, have things really gone awry? I'm just looking at number 4 in the LexisNexis definition. Everyone should have access to legal support, advice and remedy. When so few people are denied legal aid, whether through the means test or because it's just not available to them, and whether even the families of people killed at the hands of the state, so the family of bereaved people, have to actually fight and go through a lengthy and intrusive process to even see if they can get legal representation at an inquest, when they are met by a flank of government lawyers paid for at taxpayers' expense to sort of obfuscate, limit the level of inquiry and scrutiny. Where do you see the state of the rule of law, if, you know, that its very essence is that people have access to it and they don't?
No, thank you, Catherine. So, as I said 6 months ago, to preface my remarks, I'm not a lawyer, and I'm a kind of interloper in this conversation. But my kind of part of this conversation really is how the profession, how law is perceived. And look, I think your opener there it lays a lot of the ground. People are getting further and further away from access to law. My argument might be that the law needs to work harder all the time, not just occasionally, in terms of public consciousness. We've been talking a lot about the Judicial Review Bill. I'll come back to this, but of course, that was in a government manifesto. Now, to Helena and Baroness Hill's earlier points, we see governments dropping ideas, do we not? Like international aid, that was in all parties' manifestos, that's being dropped. So there is an opportunity to move things, but I think the law needs to be more part of wider public consciousness, more part of the mainstream of the conversation, more of the time. Otherwise, it's just an echo chamber. Since I've last been with you, I've also been a juror. I've been a juror in a Nightingale court. And it's the first time I've been a juror. I was summoned last time when I just set up my business, and they gave me a buy at that particular point, but I didn't get the buy in the middle of a pandemic. I was hugely impressed by 2 or 3 things. Firstly, the ability to continue with jury trials through the midst of a pandemic, which has been admittedly incredibly difficult, but it worked. I saw every part of the process work, and work pretty effectively. The problem, and you outlined it up front, Catherine, is that I think the number you use about 57,000 cases that are piling up. I was sitting with 11 other lay people looking at and deciding on events which had taken place in the autumn of 2018. Yeah, and I know by talking to some others in the law that there are cases being slated in for, actually, I was told earlier today, 2024, for events which might have happened in 2017. 2 of the policemen that gave evidence in my case had retired 18 months earlier. There are huge questions that are now, emerging in terms of the operability. But that said, I take my hat off to the court service. I take my hat off more widely to Ministry of Justice for keeping the show on the road. But to this earlier point that you were pointing me to, Catherine, I mean, access to justice is getting further away, but also when you get in the room, it was pretty obvious to me that that as you get further and further away from events, clearly there are questions which are going to emerge as to whether or not there are going to be miscarriages of justice, because we just don't have recollections and how does the law operate effectively. But there are some reasons for hope, and I think that looking, for example, at the Supreme Court judgment on business interruption for lots and lots of small businesses, that was a judgment which got a significant nod from politicians of all colours and from lots and lots of, thousands, tens of thousands of businesses that initially the insurers were not going to pay out for. The law worked, the process worked, and businesses are now being paid. If you look at the Uber judgments in terms of equality rules, another keynote judgment, that is a really redolent example that people can see. I might call it a case study, but is relevant to millions of people. So, I would argue that the profession needs to, building on where Stephanie's ended, the profession needs to just work harder at telling these stories, communicating these stories, not just popping up where there's an issue or two. One or two sort of final thoughts just up front. You probably gather where I come from, where my accent. I've been down here for a long time, like Elena, but the courts are probably going to get another big constitutional test. Nicola Sturgeon is going to attempt to, I think, take this one all the way to the Supreme Court in terms of the prospect of a second Scottish independence referendum. So the questions of the will of Parliament, we're about to have a question of the will of which Parliament, and how the legal profession plays its part in that story. Very, very important. If I can say that to an audience of English and Welsh lawyers. Final point really from me is, how do you play your part in the recovery? All politicians are talking about building back better. So how does the legal profession, for me, the business interruption story was a really, really good case in point. The equalities Uber case, a really good case in point. How does law allow a better society to be created? How does law allow those red wall seats to be leveled up by creating more opportunities for people? The more the profession can depict itself as part of the recovery, part of the solution, not, shall we say, a blocker to the future, I think the more political and public and voter, if you like, traction you'll get.
James, last but not least, as someone working working at an international business, albeit one focused on the law to a degree, what are the most important backward steps from your point of view?
Thank you. I'd jump off from Iain's point, which is you're right that how the law plays a role in the economic recovery post pandemic is a critical part that we should make. The fundamental issue that you have is that economic prosperity goes hand in hand. It's tied directly to the protection and support of the rule of law. So we've proved with data, there is a tool and site that we developed called the Rule of Law Impact Tracker, which people can look up in their own time, that takes the World Justice Project's data on rule of law compliance around the world and maps it against socio-economic measures. And it shows that in countries which have a high score for protecting the rule of law, they have a high GDP per capita, as well as other important socio-economic measures, and countries with a low protection for the rule of law have a low GDP per capita. In other words, where the rule of law is protected and upheld, economies prosper, and where it is not, then economies do not prosper, they falter. So if you want the answer to what concerns businesses, what would concern an international business, it would be the erosion of the rule of law, because without that, you start to see a decline in economies. And fundamentally, businesses need economies to flourish and prosper in order for their business to grow. There's no argument or no denial of that interest from a business perspective, but that should drive an interest in the rule of law. If I then think about some of the points that we've discussed, Iain, I think, makes some really valid and interesting commentary about some of the recent cases that have been heard by the courts and the impact that they have in people's lives. I would agree with him. The point that I would make is that I don't think there is a question that the courts generally would listen to these cases and consider them and do that on the basis of what's right or wrong in terms of the law, and not necessarily in terms of, you know, supporting big business or supporting the government. And I think you've seen that in those cases. It's not in the insurance industries, which is a massive business. It's not in their interest to decide on business continuity in the direction that they did, but they have. It's not necessarily in favour of the huge number of companies that employ freelance or 0 hours workers to decide in the direction that they have in the Uber case, but they have. So you can see that there is that independence of the judiciary, but it's continually threatened. We've already talked about the Folks Review as a very good example of how that's threatened. We mentioned that the prorogation case was an element in that. I think it was an element, but I don't think it's the only element. I think it's one of a huge number of high-profile cases that the government has lost, whether at judicial review or just in the courts, which comes back to a trend. At some point, you've got to look back and say, why is this happening? Why am I continually not doing well when I get before the courts? And it's one of two things. Either the courts are against me or I'm doing something wrong. And I think if you look at the track record of various other things that have taken place over the course of the last couple of years and including the last 6 months, you then start to see a trend which points out that it's more likely the latter than the former. So, for example, the Queen's speech was a shopping list of challenges to the rule of law. We've talked about the Police Crime and Sentencing Bill. We've talked about the potential bill on judicial review. We haven't talked about the Electoral Integrity Bill, which is looking to introduce voter ID. When in 2019 there were 47 million registered voters and 33 alleged cases out of 47 million registered voters, 33 alleged cases, that's not even the ones that were found to be real, of fraud. So why are we bringing in a bill which potentially disenfranchises a large group of people? There are other acts within the Queen's speech. We've talked about 3 of them there, but there are other acts talking about legislation on immigration, legislation enabling or changing the ability of governments to call elections. And all of this is part of a narrative which the government do an incredibly good job of. Stephanie mentioned earlier on that there is huge support within the public for the concept and the principles of the rule of law. And I would agree. My challenge is it doesn't manifest itself in anything. Because when you think about the main way in which people can reject the way a government goes about its business is through the ballot box. And wherever there has been an opportunity in recent times, and including in the last couple of months, there doesn't seem to be any swing away from the government. What it does very well, this government, is when a challenge is raised, they say quite convincingly, people aren't interested by that. What they're interested in is this, 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 and this. And the narrative is changed very quickly away from what are critical issues that are challenging the rule of law and on to, actually what you should be interested in is this and this and what I'm telling you to be interested in. So from a kind of pure business perspective, I would say I remain deeply concerned as to the erosion of the rule of law. This is not a party political thing. I'm actually archly apolitical. I don't particularly like any political party in favour of another. This has nothing to do with party politics. It's about the manner in which you carry yourself and the value that you place on the rule of law. And time again, you see it being devalued and rendered less important than pursuing certain agendas. So if you were asking me what from a business perspective I'd be concerned about, we need the economy to grow again, and the economy will not grow unless the rule of law is protected.
James, I like your business case for the rule of law, but looking at some stats about the places in the world where this is the most popular for international arbitration. Now, Hong Kong and China are extremely popular, and they're not known for being respecters of the rule of law. So what's going on there, do you think, very briefly?
Yeah, it's a really interesting thing. So number one, my point on economy and the rule of law is not causation, it's correlation. The two go hand in hand. I'm not saying that one causes the other. The second is that if you look at China over a period of time, GDP growth has slowed. It's still strong, but it's nowhere near what it used to be. And arguably what you've seen in China is a massive population that has been subjugated over time, that has grown the economy, that has then developed into a burgeoning middle class, which is then less capable of being subjugated in the same way. And there are various papers written by people far more intelligent than me, looking at the trends in China towards elements of the rule of law. Let's remember the rule of law is not an on and off binary switch. There are degrees to which the rule of law is protected and supported. And so one can have situations where the rule of law has improved. And it's known that the Chinese government have looked to the rule of law, although they haven't embraced it fully, as a way to ensure that their GDP growth continues. But I think what you're seeing is this isn't something that happens 1 week to the next, it's long trends.
Lady Hale, forgive me for putting you on the spot, but in a discussion about the rule of law, it would be remiss of me not to ask you about Hong Kong. Are you able to say whether you're going to continue when your term expires, or if you have any view on the continuance of the overseas judges as non-permanent members of the court there? Could you unmute yourself if you're going to?
Yes, unmuted myself now.
Super, thank you.
Number one, my term of office on the Court of Final Appeal in Hong Kong comes to an end at the end of July, and I don't wish to be reappointed. And that is principally because I cannot foresee a time when I would actually want to get onto a plane to go to Hong Kong. And it's not a comment on what's going on there, because the other non-permanent judges are keeping a careful eye on how things are, but they are all, with one exception for the time being, carrying on because the Hong Kong people and the Hong Kong judiciary want them to carry on. And that is because the economy of Hong Kong is closely correlated, as James has said, with the fact that there is a functioning justice system which adheres to the rule of law and has independent judges. But this, of course, is important for commercial life to function properly. The problem that's arisen in Hong Kong is because of the new national security law, which doesn't impinge upon commercial life very much at all. It's all about protests and civil liberties and the like. You can have the rule of law, even though sometimes the substantive content of the law is not what you would want it to be. That's been true in this country for quite a lot of its history. So there is no necessary correlation unless you add to your description of the rule of law one of the things that was in Lord Bingham's characteristics, which was the protection of fundamental human rights. If you don't have the protection of fundamental human rights, well then maybe your adherence to the rule of law is diminished. But as I say, at the moment, Hong Kong has an independent judiciary. It is functioning in accordance with the rule of law, at least as far as commercial law is concerned. The jury is out, of course, on how they will be able to operate the new national security law. There are all sorts of question marks up in the air. But the last thing I want to do is to do anything which makes the life of the Chief Justice and the permanent judges and the non-permanent judges any more difficult than it already is.
Thank you. I think Helena would agree with that addition to the fundamental aspects of the rule of law, protection for human rights.
Yes, I mean, I understand entirely why LexisNexis has this kind of, more traditional definition of, because they're dealing with the world and sometimes the very words human rights create a flashpoint in certain administrations, and to move people along to at least access to the courts and so on would be progress in lots of places. But I am of the Tom Bingham school, and I believe that in the contemporary world, the rule of law means a rule of law imbued with human rights standards, and certainly we have been, I think, a proud protector, by and large, of human rights. I mean, I proudly tell the stories of what happened with regard to the detention without trial of people, after 9/11 and all of that, and the ways in which our Supreme Court reasserted the right of people to a fair trial and so on, so protected the human rights. I mean, some would say that the common law was capable of doing it too, but there was that way in which our Supreme Court really did make the difference. Then again, in the case which was about should we be receiving evidence based on torture, and again our Supreme Court made a profound and vitally important decision, taking the lead in the world on this. So I believe that those standards are part of the thing that makes our tradition for respecting the rule of law great in the world, and I would hate to see us retreating from that. And I hope that this review of the Human Rights Act isn't going to be creating some kind of, lesser system. And you got to remember, I was involved in a commission for the coalition government that looked at a British Bill of Rights. And what became very clear was that there were certain people on that commission who basically wanted a sort of set of rights for, true-born Englishmen, and another set of rights for folk who were kind of a lesser order. And I think that you should worry about things that set up those kinds of hierarchies of rights. And so I do think that human rights has to be part and parcel of, but all power to LexisNexis. They're going around the world and promoting the rule of law in the way that they do. And so I'm not in any way being critical in saying, but for me, it's a bigger thing.
Thank you. If we can look a bit more at sort of where do we go from here? And I think a big part of it that they wanted to discuss tonight was how do you make the public care about justice and the rule of law? Iain's touched on it a little bit already, but what does the panel think is the public perception of the rule of law? Do they care? Do they understand? I mean, when they see things like the post office scandal and Hillsborough, and families not getting justice for years at inquests, victims of crime not getting the justice that they want. Iain, what do you think is the public perception, and how do you change that, most importantly?
Yeah, so you're right. I mean, you see that Hillsborough case, that story as it then becomes in media terms, and you shudder. You absolutely shudder, and you think, my goodness, what do these families have to do? And that really does resonate. But as I said a bit earlier, equally, when you get a ruling like the Uber ruling, you get a ruling like the business interruption ruling, that resonates too, because it also affects, in fact, in both of those cases, it affects millions of people in their daily lives. It's useful to millions of people in their daily lives. So I think the profession is guilty of what every industry is guilty of, and I would argue all the time, Catherine, which is don't just keep popping up on issues. You need to keep telling the story in a very, very consistent way. But look, I mean, a part of what we've also been discussing this evening in some depth so far is that judicial review bill, which comes from a manifesto, which comes from an idea of the will of Parliament versus the judiciary. And actually, I think that there is a big job of work to do, and whether or not this is the Law Society or other parts of the profession, in order to make the point that this does not need to be adversarial. This is the whole purpose of law. It is to sort stuff out. But, and I think this is going to resonate more now than ever before, given the fact that in a way we've all been in our own sort of personal captivity for the past 15 months. And that is how law can support the economy. Very, very struck about what Baroness Hill was discussing there and the kind of contours of the debate that's going on in other territories right now. If the law is seen to get in the way of economic recovery, or perceived to get in the way of economic recovery, let's just carry on that example of, I think the Financial Times the other day, when talking about the judicial review bill and the legal profession's concerns, which we've heard earlier tonight about the legislation, took it straight into that business perspective that I think James was talking about, which is any building back better, building bridges, building hospitals, building runways, if judicial review is going to get in the way of a economy that needs to rebuild, is the legal profession going to be on the right side or the wrong side of that conversation? Now, the profession's argument is always, of course, about access to justice and some of the principles that we've heard earlier. But the political response, I'm not trying to put on any party hat at all, but the political response will be, is the legal profession getting in the way, in a way, getting in the way of progress, getting in the way of how the economy rebuilds. So I think it's got to be very, very, very mindful of that, but not just keep popping up. It's got to keep telling its story and how it actually sorts an economy out, makes an economy work, makes a society work, and not just do that around either particular pieces of legislation. Try and more tightly define what it does with what it enables society to do.
Several things, Iain, that you've said there seem to lay down a challenge for Stephanie and the Law Society. Interested in one thing that you said there about the lawyers being on the right side, and isn't that potentially problematic, where you have lawyers then perhaps identified with the clients or the sides that they're on, when in fact, as you know, lawyers, that they are just the mouthpieces. They're not there generally. I mean, you obviously have some campaigning lawyers, but that very point, doesn't that risk undermining the rule of law, where you equate lawyers with the clients that they represent? Stephanie, can you pick up on Iain's the challenges laid down for lawyers?
Well, absolutely. I think there's some profound misconceptions about the role of legal professionals. Being or at the heart of a legal professional is, as Catherine said, being the mouthpiece for their client, ensuring that individuals can, ensuring and enabling individuals to access and exercise their rights. And so there has to be legal education, public legal education, to ensure that those misconceptions which can lead to damaging the trust that the public has in the profession, the legal profession, is not there. And what we call for, the Law Society, is public legal education, so that there is significant engagement around some of the misconceptions that individuals, that the public has, because we know, for instance, that the public do not readily understand the work of legal professionals or the role that we play in the justice system. We have, at the heart of all of this, we have a job trying to gain the public confidence in the legal profession, the roles that we do, enabling people to exercise their rights. Because after all, legal rights mean absolutely nothing if individuals don't know what those rights are, or indeed they cannot exercise those rights. Coupled with that is the misconceptions around legal aid, and the chronic underinvestment in our justice system. We need to get the public thinking about the justice system, not when they're caught up in it, but thinking about the justice system and the role that legal practitioners play in the justice system, as we do, as the public thinks about the NHS. It is a fundamental British product that should be valued, England and Wales, global jurisdiction that should be valued, a centre of excellence across the world, the independence of our judiciary that we've heard already today, that we represent legal professionals, that we represent our clients without fear or favour, but we do our job to the best of our ability. So there is a whole swath of public legal education that starts early, and that starts in schools as we start to teach. As we start to teach law in schools, to try and break down some of those misconceptions and myths that the public has about legal professionals and the role that we do play in the justice system.
I hear what you say about public legal education, but is there a role also for parliamentarian legal education or political legal education? How do you make the politicians understand what's important? And I don't know if you can give us any insight with your dealings with the Ministry of Justice about, what they actually think about what lawyers do, what their role is, and do they understand the rule of law, the politicians, not the lawyers?
Well, we've seen some instances over the last couple of years of the attack on legal professionals, the integrity of those of us whose role it is to either defend or represent our clients. And legal professionals should not be in fear of intimidation for carrying out their role, and that is representing their clients. So quite rightly, parliamentarians are members of the public, unlike, like anybody else. There is public legal education that is needed amongst parliamentarians. And if they legislate for that, I know that there is much work that that goes on in Parliament around public legal education. But quite clearly, that needs to be, as I'm often reminding colleagues when I speak with them, about the necessity, as we see the police crime sentencing courts bill, that if you are going to move towards this virtual way of working around remote juries, remote observations, it must be coupled with public legal education, so the public understand the court etiquette, the do's and don'ts, and what they perhaps potentially are involving themselves in, so they don't fall foul of the justice system and end up with a criminal record, or potentially a criminal record.
Oh, I should have reminded the virtual audience that you can put questions for the panel on some clever thing. I don't know what it is or how to do it, but you can. So if you're clever enough to work it out, do it. Do submit them. We will get onto them in a minute. But James and Lady Hale, coming back to both of you on this, looking at, again, the public perception of justice and whether sort of justice and the rule of law perhaps needs to be rebranded, or lawyers or judges do. But what about the effect of the lack of diversity within both the senior echelons of the legal profession, the bar and solicitors, and the courts? And then, I mean, how does that affect the public perception and public either trust or interest in what the judges are saying and doing? And then where we have these allegations that judges have bullied other judges, I'm thinking of the case of Claire Gillen, who she was left alone by the judiciary to take a case to win whistleblowing rights for all judges. I just wonder how much all of that affects the public trust in the judiciary. Do they trust do they trust judges or politicians more, or neither of them? Perhaps James first and then Lady Hale.
That was not the order I was expecting you to go in on that question.
Sorry, I wanted to give Lady Hale a little more time because it's probably harder for her to answer those things.
Answer delicately. So yes, let me say this. Let me answer the last question first. Do the public trust judges? Yes, I believe there was a study recently done of the level of trust of different professions, and judges and lawyers ranked particularly highly. So I don't think there is particularly an issue there, but there is a huge issue in terms of diversity of both the profession and of the judiciary, both in terms of ethnicity and in terms of gender. That is something that I know the Law Society has done a lot of work around in studying and surveying, and is continuing to do. In fact, there's a partnership between LexisNexis and the Law Society to do a global survey on the levels of diversity within the law, which will be a fascinating report to read once that's completed and published. But I do agree that one of the challenges that faces us is if you don't understand the person in front of you, and if you do not understand the life that they have lived and how it has led them to reach your door or reach your courtroom, then it's very hard to understand their motivations and therefore kind of make some kind of determination on what would be a reasonable course of action for them to take in a set of given circumstances. Where that starts to become an issue from a rule of law perspective, if it weren't one already, it is when you start to see threats or discussions around the reductions in jury trials. There have been a couple of papers written by a professor, I can't remember her name, but I can dig it out and put it on the chat, that looked at the criminal justice system and found that the only stage in which people from a Black, Asian or minority ethnic background didn't face discrimination in proportion to their proportion of the society was at jury decision.
I think, just to interject, I think that's Cheryl Thomas, isn't it? The
Yes,
research
correct.
that
Professor
she
Thomas.
did, Professor Thomas at, I think, UCL.
Yes, correct. So fascinating study. And she's written about it in 2 separate papers. And in both, the conclusion was the only stage of the justice system in which people from Black, Asian and minority ethnic background are not disproportionately treated unfairly is at jury trial. And yet there are conversations about limiting the scope of jury trial and handing that, putting that into the hands of magistrates or the judiciary. So I would say there is a huge concern from that perspective.
Lady Hale, diversity in the judiciary and allegations of bullying judges, and was Claire Gillen sort of left by herself wrongly?
Well, number one, diversity. I have been banging the drum for greater diversity amongst the judiciary for decades now. So I don't want to repeat all the things that I have said about it for ages and ages. Not only gender diversity, but also ethnic diversity and professional background diversity, because diversity of professional background is likely to lead us towards another element of diversity, which is a socio-economic background. Because one of the problems, obviously, is that by definition, when you become a professional lawyer, you become middle class, and you may even have come from the middle classes in the first place. But we do need people who have got a wider experience of life and come from every sort of background in order to have a properly diverse judiciary. And one of the main reasons for that, there are so many reasons for it, and I don't want to give my standard stump talk on diversity in the judiciary because most people have heard it all before. But one of the main reasons is public confidence, legitimacy, that people can look upon the courts as their courts, not some beings from outer space that have been beamed in to run their lives for them. They should have confidence that they will get a fair hearing from a court which understands them. Of course, one hopes that a judge will be somebody who understands them, and greater diversity on the bench does help with that, because the more different people you have around the table, even at first instance courts where judges sit alone or with juries, the more the conversation opens up and casual racism and sexism become unacceptable. So there are all sorts of reasons for saying that we need a more diverse judiciary. We are, of course, getting a more diverse judiciary. Again, I have been banging on about this for decades, and things have improved quite dramatically over the past 10 to 15 years since we had the Independent Judicial Appointments Commission. And that has improved the gender diversity quite considerably. There is still a long way to go at the very top of the judiciary, but actually for most people, what matters is the trial judiciary, and that they should be properly diverse and properly empathetic and properly understanding. We do need to have more diversity at the top, but I think the trial judiciary is the more important of the two, and that is improving quite considerably. And the object lesson is the tribunals judiciary, where there has always been a greater diversity, both of gender and of ethnicity and professional background. And the tribunals judiciary, on the whole, are pretty close to mirroring the proportions of women and ethnic minorities in the working population of the appropriate age group. That's more or less what they have managed to achieve. Whether they still have, that was about 2 years ago I'm talking about. So it can be done, and long may we continue with our efforts in that direction. As far as Judge Gillen is concerned, I don't think I better say anything about that, because I was on the court which, in fact, I think I wrote the judgment, which said that she was entitled to the whistleblowing protections. And of course, the rights and wrongs of what she wanted to blow the whistle about were not before us. What was before us was whether she counted as somebody who was entitled to those protections. And I'm delighted to be able to announce that for the purposes of certain aspects of the law, judges are workers.
Helena, to bring you in, what change do you want to see? I mean, how fundamental do we have to be here? Is it just about diversity and trust, or do you need a whole-scale rebrand of the justice system?
No, I mean, listen, I mean, like Baroness Hale, I've been beating on about this for many decades, and I do think that we're kind of making progress. I don't think the general public understands that that what is required at the level of the judiciary, which is dealing with appeals and dealing with the issues of law that are dealt with at the Supreme Court level, is a rather different business from the business of, you know, what happens to rape cases when they're tried, or what happens to issues where race might be an element in it, and so on. And I think that we're getting much greater consciousness about all of that in our judiciary, which isn't to say that I don't have lots of problems about it, and I think there's a way to go. And you only have to hear from, as I heard not so very long ago, from a black contender for the judiciary, which was the Crown Court judiciary, that when he was told that he hadn't got through to the next round, he was told that he didn't have enough authority. And I always wonder what that means, you know. It's one of those sort of words that, you know, you really wonder whether it was because he had an accent that they didn't think was grand enough, or what does that mean? And so I think that we find that notions of merit can often be laden with potential for discrimination, you know. So I get worried at that. But I really wanted to take up the issue, the more general issue, which is about about justice and so on, is that I really do hope, Stephanie, that as the president of the Law Society, because your background has not been in the criminal courts, but mine has, that we just heard from Iain, as a highly intelligent member of the public, takes part in a jury system, and how impressive it is. Because people, by and large, the failures of the system are usually because the evidence that's been presented to them has not been satisfactory. It's not because they don't really agonize over what they're doing, think hard about it, rise above their, by and large, rise above their prejudices and so on. So I believe in it. I'm a believer, and I do not believe that you can do it virtually. And so it will be a nice, cheap and easy way to go. It will not deliver the quality of results that the current system does. Now, if you want to cut those numbers, I just want to invite people to consider a little possibility. There is in the fraud area, the white collar crime area, the business of dealing with serious big time fraud. There is a way in which, when it comes to light nowadays, it's possible to have delayed prosecutions, suspended prosecutions. Who knew? The general public doesn't know this, but there are suspended prosecutions where corporate leaders can actually say, get your house in order, get things sorted, and if over the next number of years, then you won't be prosecuted. We should be doing that with a large number of these cases, where we should be saying there'll be a suspended prosecution, and if you keep out of trouble for the next whatever it is, then you won't appear in court at all. And I think if that were explained by a sensible Lord Chancellor to the general public, they would agree that rather than have the system collapse, that would be a good thing to do. And I think there are lots of things like that where you think outside of the box, but you actually do try to, at the same time, adhere to the system of justice. You've got to be very considerate of victims and so on. But please do not go down the route of going along with the government of wanting to abandon jury trial in order to save money. So that's the first thing I wanted to say. And the other thing I wanted to say was that, many of the complaints around judicial review, and I say this to Iain, I promise you, the idea that our judges are going to be somehow making decisions which are going to inhibit the great opportunities that there might be for business to get back on its feet and our economy to recover and so on. It's just, judicial review is not going to be used to inhibit that, let me tell you. And our judiciary are not going to be that way inclined. But what our judges do, and I mean, this business of seeing it as an adversarial thing, our judiciary against the political class, we mustn't allow that to take hold, because it really, the idea that Parliament is supreme allows for majoritarianism. And that is that, you win an election, you get plenty of folk in, and you can pass any old law that you like. And that somehow you make the claim, but this is what we, the elected representatives of the people, have put in place because we put it in our manifesto and the people liked it. Well, the people might like all kinds of horrible things. And we have to always remind ourselves that one of the efforts that was made after the Second World War was that too many judges felt that that was all their job was. Their discretion went out of the window, and what we see governments doing is they always want to limit judicial discretion. What we saw happening was judges appeared on trial at the Nuremberg trials and said, I was just doing my job, I was just administering the law that Parliament passed. You have to introduce a value system into your judicial system. That's what the rule of law means. There have to be values in it. And you don't just, you don't turn this into judges versus, the judges are supposed to be independent. And the independence of the judiciary is for the protection of the people who are not perhaps part of that majority, who are not the ones who are calling for immigrants to be ousted and asylum seekers to have no rights, but to be locked up in detention centres where the conditions are absolutely abysmal. We had Judge Linden today making a decision that the conditions in which people are being detained are a disgrace and contrary to human rights. Judicial review, let me tell you, is a vital part of retaining justice for those who have little voice, but not exclusively. But look at Hillsborough. Hillsborough would never have got the inquiry that they got, the opening up of a new inquiry, if they hadn't had access to the courts through judicial review. review. You know, the case of the barracks where young women were being bullied and harassed and sexually intimidated and sometimes raped, that culture was exposed through the parents of a girl who was ended up taking her own life, being able to get an inquiry by going for judicial review. You have to have those processes kept in train, and it mustn't be seen that judges are somehow, and the legal world is somehow in opposition to the political world. We've really got to make that message very clear to the public.
And can I say, Helena, that the Law Society, in case I wasn't clear, the Law Society is not for remote juries. We have a number of concerns, most of which has been echoed already this evening, but we do not favour, and in meetings with the Lord Chancellor and various others have made our position very clear that we are not in favour of remote juries.
I'm really glad. Thank you.
Helena and James have both touched on criminal law, and James in particular touched on the magistrates' court, which is often neglected, given that that's where the majority of crimes are dealt with. The sexier and more high-profile matters in the Crown Court tend to grab the headlines. And there's a question from somebody in the audience about magistrates' courts. Looking at they ask about the number of magistrates which have halved in the last decade, and they ask what effect does that have on the rule of law? But before I ask for any of the panel's comments, it's not just cuts in the magistrates themselves, but the number of courts. In the Times Law pages today, it referred to the old Bow Street Magistrates Court, which is now a hotel, where if you've got the money, you can spend £1,500 a night to stay in the magistrates suite. But you've got the closure of local courts, so you've got less local justice and a reduction in magistrates. How does that affect the public perception, really, of the rule of law? Because that's where the majority of the public who find themselves within the criminal justice system meet justice. Stephanie, perhaps if you have a thought on that.
Well, absolutely. The ability to access justice should not be dependent on wealth. In a country such as ours, and that's why legal aid, the provisions of legal aid is so important, and government should invest in legal aid, in public funding, to enable those who cannot afford representation or indeed the ability to access justice should have that option. As I said earlier, we have seen year-on-year reductions in investment in the criminal justice system, to the point that we have substantial backlogs in our courts. I think over 500,000 last count, 57,000 or so in the Crown Courts. As I say, the pandemic has exacerbated that, but it's not the cause of it. That has been successive underinvestment by successive governments over a period of years, cuts in public funding and so forth. Confidence in our justice system by the public is waning. We were originally told that you would live within 30 minutes of being able to get to a court. We have seen instances where that is not correct. There are parts of this country, counties, where if you are charged or fall foul of the criminal system, that the ability to gain representation from a criminal defence solicitor is almost virtually impossible. The government needs to get on side and understand that the justice system is creaking. We are in a real emergency, and investment funding is needed. Or, this global legal centre that is revered around the world is under threat if we do not have a properly funded justice system.
Lady Hale,
sorry, Catherine, can I just make a quick comment on that? Is that?
Yes, of course.
So I think everything you've said, Stephanie, is absolutely spot on. But to the sort of starting point of having just come off Times Radio, and we're all very comfortable with places like that, this needs to be a mainstream story. You know, the fact that magistrates, I didn't know till you just said it, Catherine, number of magistrates have halved. Most people won't know that. Yeah. So the profession's got to do a better job of trying to mainstream this conversation. Maybe actually getting occasionally a bit edgy and provocative to burst through. You know, the papers are filled today about the government's education plans because somebody quite high profile has resigned. Someone has stepped back. Someone has said, no, up with this, I will not put. I wonder whether or not there's a moment for somebody senior in the profession to do something quite dramatic, to create rupture, in order to create public consciousness. The legal system doesn't necessarily create rupture. Final thought, I think that politicians play on the idea of who cares about legal aid and who cares about access to justice, because this law thing is happening to somebody else. Yeah, I think that there's a much more potent idea, which was this could happen to you. You could be divorced, you could be sued, you could be burgled, you could have rights taken. This could happen to you. Yeah, it's not just happening to somebody else. And I think if you create that, if the profession can create that more visceral link, this could be you. You could find yourself in this situation, and you're going to want to be tried and tested fairly. To Helena's earlier point, in front of your peers, because that is tried and tested. It's the best system that we have. But this is not just something that's happening to somebody else.
Well, absolutely, Iain. And the Law Society has produced a number of resources, guidance, going into schools and so forth. But this goes back to my earlier point around public legal education and taking that into schools. Let's add law to the national curriculum. I know Lady Hale has done, Baroness Brenta-Hale has done a number of different things trying to educate our young in respect of the law. But the legal profession can do so much. But this has to be, as we spoke about before, a number of professions, a number of bodies coming together to as I say, to get our country, our citizens thinking about the justice system as we do the NHS.
Looking at the potential loss of local justice, which I think perhaps the question about magistrates' courts alludes to, but where local justice is under threat, can technology take its place in any way? We've done the Supreme Court seems very much ahead of the game from the other courts being televised, and people are now used to Zoom court. Can televised court hearings or the internet technology, can that step into the gap where local justice is disappearing? Either Helena or Baroness Kennedy or James.
Well, let me immediately tell you that I am absolutely against televised court hearings at the lower levels, at the levels where, you know, people are having to make judgments on truthfulness, on credibility. They're having to hear evidence that is sort of real and live, and I think that that is not helped, because what happens always is that, televising these things, it will never be the whole thing, and you end up getting the sort of, you know, the juicy bits go on that night's news and stuff. So I don't think that we're talking about television here. Are the ways in which one could use more virtual things? I certainly think that for many of the lesser, you know, the sort of interim hearings and so on, as already is happening actually, you can then use Zoom and other platforms. What I do think though is that I mean, I happen to take a strong view that the magistrate system again is one of those great riches of our system, because it allows people in the community to become involved, and they then, of course, often go on to take part in other parts of the system, which is about, the parole board. It's about prison visits. It's about those people who, turn up at police stations to see how people are being detained. They often end up being involved in many different aspects of the system and become very, very knowledgeable. And so I feel it's another of those ways in which you can draw in members of your community and build on the resource of civil society. And that's another of those things that enriches democracies. It's where you have a vibrant civil society with people participating as jurors, as magistrates, knowing how the system works and taking part in different bits of the system. All those things contribute to enriched democracies, as does the independence of the judiciary and a free press. And unless you have all of those things, you start withering on the vine. And I'm worrying that this business of us not being in the same room as we aren't tonight could end up thoroughly damaging things that are of real importance in engagement of the general public in our institutions. So I'm all for magistrates' courts. I think that they should be kept going, and I think that there should be more of them. And if necessary, we have to, have them reawaken. I mean, basically, let's be clear. The reason for closing down so many of those courts was because they were prime real estate, sitting in the centre of towns, and they're now either wine bars, hotels, or they're blocks of apartments. And so, this was about enriching certain folks, and it was about diminishing what towns should be about, and your local court, your local library, your town hall, all of those things should be maintained, in my view.
Unless anyone has anything else strong they want to say about magistrates' courts, Lady Hale, James, or televised courts.
Yes, I do want to say something, if I may. I want to agree with every word that Helena has just spoken, but we have already lost a lot of local justice. I come from North Yorkshire. If somebody gets burgled in my town, or raped or sexually assaulted in my town, forget rape, let's keep it a magistrates' court type offence. They have to go a very long way to get to court to give their evidence. Who is going to be able to do that? Who is going to be able, want to go all the way to somewhere which is not within easy reach by public transport, and they may not have a car, they may not have the technology to do it remotely, even if we do have remote hearings, which I'm not in favour of, like Helena, for witness actions and hearing witnesses. What we need to replace what we have very sadly lost, I think, are mobile courts. We need a caravan court, which consists of a judge and magistrates and an official, and it tours around the various towns and villages and enables real local justice to take place. Because without having real local justice for the small things, we won't have people's confidence that the law is there to help them. It's the little things that go by the way unless you've got real local justice available. We need to get back to that situation. And there are good, cheap, efficient ways of doing it. So that's another Build Back Better thing.
Is there a model for that anywhere?
Well, let me tell you, I don't know about a model for movable courts, but I do know that there's a model in Malaysia. I've got a great friend who is now, an older person like me, who set up many years ago a legal aid system in Malaysia, which was based in a traveling van. I mean, it was basically one of the sort of thing. It was basically that they went from village, town to town, and they would be at a different place at a particular time on a thing, and people would queue up to get legal advice on the problems they were having with their landlords, the problems they were having with all manner of things. And I actually do think that business of bringing the law, bringing legal advice, things, bringing court hearings of a lesser kind to the people is a way to go. Brenda Hale and I are going to get together and we're going to set these things up. We're going to be two older women who are going to try and regenerate the legal system when she's properly retired.
The ladies in the van.
The ladies in the van, not just one lady in the van, but two.
Catherine, can I add one final thought on that just before we draw it to a close, which as compelling an image as that is, and just to pick up Iain's point from earlier on, that lawyers need to be a bit more vocal or a bit more edgy. I think with some of this, we also need to break through, and Iain is a great example of someone willing to come on a debate and a discussion with a load of lawyers, and probably most of the participants watching this are from the legal profession, and have this discussion. What we potentially need is more people like Iain, or for Iain to bring us with him into a mainstream world where we actually have this conversation in front of people who are not lawyers or with people who are not lawyers, and help to take it on to another level. And you know, that will be a perfect opportunity to advertise the ladies in the van service, but also to bring this message of the importance of the rule of law to a wider audience.
I also just want to say that I want to be invited by Iain to come and have dinner, because that kitchen behind him is so fabulous that I can only imagine he's a really fine cook as well as everything else. Anyway, it's very brave of him and good of him to join us to talk about law.
Mary, have we time for one more? Mary and James.
Yes.
James has maybe answered it in a way. This is a question from Toby Brown, who we heard from at the beginning. He asks, would each member of the panel like to make one suggestion on what members of the legal profession should do to support the rule of law beyond their day jobs? James, you seem to be suggesting they go out and talk to people who aren't lawyers rather than twittering among themselves on Twitter, winding themselves up and listening to debates with other lawyers.
Fundamentally, yeah, I totally agree. Yeah, that's exactly what I'm saying. The law is a huge echo chamber at times, and we can be very insular, and it can be hard to understand. But what we need to do is take that message out to businesses, to business leaders, to people who are at the front line of the media, try and make it digestible, and partner with them. So say, look, we'll debate this together. You won't be in a position where you're asked difficult legal questions, but let me explain in real human terms how important this is. And we do this at LexisNexis through kind of business for the rule of law cafes, where we bring business leaders together, non-lawyers a lot of the time, and talk about the projects that we're all working on to try and advance the rule of law. And that can make a huge difference. So if you want a snappy, Toby or yourself wants a snappy line for that, it's adopt a non-lawyer and bring them into the discussion.
Stephanie, that sounds like a particular, another challenge for the Law Society.
Oh, and just to remember that the Law Society, of course, is one branch of the legal profession. There are others as well. But certainly, I mean, later this year, we will celebrate 20 years of pro bono work. And of course, the legal profession does a huge amount of voluntary pro bono work currently. But of course, quite rightly, we can do more. We've taken on board, I will have taken on board some of the comments made this evening. So watch this space. Thank you.
Lady Hale, how can lawyers help beyond doing what they do?
Well, I'd have thought number one is actually going into schools. Every school should have, from time to time, a visit from a lawyer, and for that matter, a policeman as well, to have a lively discussion about what the law is and what it can do for them, as well as to them. Most people tend to think of the law as doing things to them, and we need to get across the message that it can do things for them. And I think the place to start, as we've all agreed, is in schools, and that's something that we can all do, along with, of course, children's books. Plug, plug, plug.
Oh, yes, you have one in mind, ladies.
For a particular children's book, which is all about trying to educate primary school children in the importance of the law and what it can do for people. not just two people.
Brenda's being too humble. There's a wonderful book which is about Brenda's life, and starting it in Yorkshire and ending up being a judge, and a little girl telling her story of winning a trip to go to London to the Supreme Court to meet this great Yorkshire lass who became the greatest judge.
Equal to Everything, I think.
I just mentioned that.
Equal to Everything, published by the Legal Action Group, and I think the proceeds go to them. So
it's great.
James is holding it up.
Great, there you are.
James has got it. Yes.
I want to say to all of the lawyers out there, you know, I remember when my kids were small being invited to the primary school. They've got all the different mums and dads to do this, but I went along to tell them about the law. And let me tell you, kids know from quite an early age, you know, when they're 7 and 8, they know what it means when things are unfair. When you say, you know, have you ever had anything happen to you that's not fair? And they will put their hands up and they'll tell you. And I brought along my wig and gown, and they were really interested in knowing about what justice was about and why it mattered. And you can talk at that level, and you can talk at the secondary level if your kids are at schools, and offer to do it to the local school. But the other thing that I wanted to say was that Stephanie said something when she spoke earlier about the role of the Law Society. And I think it's the role of every single lawyer. We are the stewards of the rule of law. And one of the most important things is to protect our independent judiciary. Because I tell you, I feel that it is they are under threat, and I watch as the press attacks judges and so on. And I'll never forget that horrible headline in the Daily Mail, "Enemies of the People." We really have to protect our judges because they are independent, they are vital to our well-being as a nation, and we have to not allow politicians to go after them. So that's what we all have to do. We have to protect the judiciary, we as lawyers, because judges often can't do it themselves.
Iain, the last word to you as the only person on the panel who's not a lawyer. What should lawyers be doing? What would work for you, a member of the public?
Again, I don't know if not being the lawyer is a good or a bad thing tonight, but you be the judge in that regard. I'm a recent juror, which is as close as it gets. So look, completely echo what Baroness Hill and Stephanie and Helena have said. One of the best things I do is Robert Peston's initiative called Speakers for Schools. And I deliberately go into schools that never get the speaker. Do you know what I mean? The schools that always get the speaker, always get an opportunity, always get a lawyer because there are lots of alumni. I always go to the schools that never get the speaker. And I get such a kick out of that. I'm absolutely buzzing when I do those sessions. So, Mary's put it in the chat. So Speakers for Schools, I don't know, well, there's a collaboration, Stephanie, between the Law Society and Speakers for Schools, but it would be something like that would be absolutely fantastic. To the more substantive threat to the sector point, and I would say this as a communicator, but okay, almost impossible for the judiciary, but not impossible for lawyers, for barristers themselves to get out there and make the case, not occasionally, but all the time. And if I can leave you with one thought, Catherine, which is, can the profession think about that rupture moment? Can the profession think about that Marcus Rashford moment, if I can put it that way? There is someone that has caught the public imagination and changed government policy. Joanna Lumley was another great example, as well as somebody who caught the public imagination, made people understand, highlighted the importance, and created change. You're all some of the best debaters, if you like, some of those that can construct some of the best narratives in the land. Harness that power in order to create change, but it might involve something dramatic. It might involve a kind of rupture from the from the usual way in which you'd go about that argument.
Yeah, great. Thank you. Well, there, I think, you know, some of what Iain said there, I think probably has encapsulated the whole debate. Education, education, education. Start young in schools. Adopt a lawyer. Find a legal hero, and start a legal caravan. I think we've run out of time, so thank you very much to all of the panelists. You've been wonderful, and to those of you listening.